All right, crazy kids. Equal protection clause. This stuff's pretty easy and pretty interesting. So, where do you find the notes? Open my 14th Amendment roadmap, PowerPoint, and it is several slides down. All right, so that's the background of incorporation. Then we talk about the Due Process Clause. Due Process Clause, fundamental rights. Due Process Clause, fundamental rights in the Bill of Rights, with the exception of right to privacy. Equal protection is all about discrimination. All right, so due process, you know what, forget the difference between procedural and substantive, just do fundamental rights. All right, so we're going through, and then we get to this one. All right. Okay. So, everybody get to this slide. This is where our lesson begins. All right. Due Process Clause, fundamental rights, equal protection, discrimination. Got it? Repeat after me. Due Process Clause, fundamental rights. Equal Protection Clause, discrimination. All right? Now, certain cases, we're going to talk about some, and I may not have put this in my notes, can contain both. For example, Loving versus Virginia. Laws that said you couldn't have interracial marriage. You could approach that on a due process clause. Marriage is a fundamental right protected by the Bill of Rights, right to privacy through incorporation, and you're discriminating because you're letting white people marry white people but not white people marry black people. All right? Obergefell, the gay marriage case. Marriage is a fundamental right protected by strict scrutiny, compelling state interest, and you're discriminating against gay people by letting heterosexual couples get married but not gay couples. So, in some of these cases you'll have, in the Supreme Court in their analysis does both, all right? Okay, Equal Protection Clause is all about discrimination. Here's what it says: no state, all right? Can a private person discriminate? Well, it doesn't violate the Equal Protection Clause, so they have to violate some other law like the Civil Rights Act. Remember, Civil Rights Act, hotels and other public accommodations can't discriminate, so no state. All right. The equality means the government cannot show favoritism to an individual or group. This is the heart and soul of this. Remember this. Remember this. The Equal Protection Clause provides equality of opportunity, not equality of outcome. Are black people in this country poor? Yes. Is that inherently not everybody, but a higher proportion of black people are poor. Is that a violation of equal protection? No. Okay, equal protection, discrimination. Equal protection, discrimination. Here is the rule. Look for laws that treat different classes or groups, if you can't remember classes, different classes of people differently. And if they are being treated differently, are they being discriminated against? You guys are treated differently by laws. Think of one. What is a law that says that treats young people differently than old people? Drinking age. Cigarettes. What about this? What about driver's licenses? Can 15-year-olds and 14-year-olds sue under the Equal Protection Clause? Well, there is a law that says you can't get a driver's license till you're 16. That creates two classes of people. People that can get driver's licenses, 16 and older, and people that can't, 16 years and younger. Can you attack those laws on equal protection grounds? Can't drink till you're 21. That creates a classification, right? People that can drink that are older, people that can't drink that are younger. What about this? Black students are going to be in different schools than white students. Is that a classification that treats people differently? In both these cases, the answer is yes, right? What about this one? Marriage licenses. Only heterosexual couples can get a marriage license. Gay couples cannot. Does that create a classification? The answer is yes. The answer is yes. Is it a violation of the Equal Protection Clause? Well, it depends on the class. It depends on the class of people that are being discriminated against. All right, so the Supreme Court is like, look, we're not going to start striking down driver's licenses laws or drinking laws or, laws like that. We're not going to do that. What was the focus of the Equal Protection Clause? And the Equal Protection Clause was passed after the Civil War, obviously, to protect who? To protect blacks, right? To protect blacks. So is it just restricted to protecting blacks? Now, crystal clear, the answer is with respect to blacks, with respect to race, with respect to Chinese, with respect to Latinos. If you see a law that treats people of different races differently, giving benefits to one and not the other, giving benefits to white people at the expense of black people, that is going to be subject to, here's our rule again, strict scrutiny. That law is going to be presumed unconstitutional. The government is going to have to prove that there is a compelling state interest that supports that law or government action, and that different way that the people are being treated is not only supported by a compelling state interest, but is narrowly tailored to achieve its goal by the least restrictive means. Now, national origin would be covered. There have been cases involving religion. So interestingly, if you are being persecuted based upon religion, you can argue, well, you're giving preference to one church over another. That's a violation of the Establishment Clause. You are prohibiting me from exercising my religious freedoms. That's a violation of the Free Exercise Clause. And maybe it's a violation of the Equal Protection Clause because one religion is being treated differently than the other religion. All right? Okay. Now we're going to get into affirmative action, reverse discrimination. So, interestingly, even though the Equal Protection Clause was clearly put into the Constitution to protect black people from being discriminated against in preference to white people have said, hey, it's a classification based upon race, and you are treating white people worse. You're treating white people badly at the expense of black people. The Supreme Court has accepted that argument in reverse discrimination cases. Shaw versus Reno, go back and read it. Make sure that if you've briefed it that it is an Equal Protection Clause case. It is a case where whites were saying my voting rights were nullified by you drawing this black congressional district, all right? Baker versus Carr is an interesting case because it is an equal protection case where there was no racial component. So, you know, they have recognized, the Supreme Court has recognized voting rights as a class of people, voters, that they are going to apply strict scrutiny to. Remember, Baker versus Carr said, the argument was, you know what, we're drawing these different legislative or congressional districts in a way where there's a few people in one and a lot of people in the other. Now, who is arguing they're being discriminated against? There's two classes of people, right? A group of people in a legislative district with few people and other voters in a legislative district with a bunch of people. And the Supreme Court recognized that as an equal protection case. Go back and read Baker versus Carr, make sure I'm right on that. Okay, so, suspect classes. Suspect classes, they are also, might be referred to as a discrete and insular minority. A discrete and insular minority. But the mother child is going to be race. The mother of all cases, Brown versus Board of Education, is one of our 15 cases. You'll probably, if you see a free response question on this, will be focusing on race. Maybe not, because Shaw versus Reno and Baker versus Carr are also our equal protection cases. All right. So, has there been cases where the Supreme Court has upheld a different classes of people being treated differently on the basis of race? Interesting, interesting. Which ones? Well, here's one. Plessy v. Ferguson. Plessy v. Ferguson. Now, Plessy was an octoroon. An octoroon is a person that is 1/8 black. Apparently, Plessy looked like a white man. Plessy, on purpose, this was a test case. People were trying to go after Jim Crow laws. Plessy went to go buy a train ticket. They had white cars only and black cars only. He had to tell them, hey, I'm a black guy, I'm an octoroon, to get him to sell him a black-only ticket. And then he went and sat in the white car, and then he was arrested for refusing to go back into the black car. Not because he was black, but because he had a black ticket. It went all the way to the Supreme Court by 8-1. The Supreme Court said, all right, even though there is a classification where blacks are being treated differently than whites, it is not a violation of the Equal Protection Clause as long as the separate facilities are equal. Now, that is a joke, I know, because the white cars were always nicer than the black cars. The white schools were always always better than the black schools. The black schools, the kids got the old used textbooks from the white school after they were out of date. The black schools didn't have busing. I've heard stories about the bus going by with the white school kids in it, passing a black kid walking to school. So this was a sham, but this basically gave Jim Crow life in the South, because you could just always argue, well, even though they're separate facilities, they're not equal. Korematsu. During at the outset of World War II, when we declared war on Japan, President Roosevelt issued a what? Executive what? Starts with an O, right? Executive order. I forget the number of it. It's a very famous number. But he issued an executive order that said all of the Japanese living on the West Coast have to be moved off of the West Coast into concentration camps. I mean, they were basically concentration camps. You know, interestingly, it wasn't only Japanese immigrants, but it was the children of Japanese immigrants who were Americans because they were born in the U.S., and the 14th Amendment says if you're born in the U.S., you are a citizen. So they didn't, it wasn't just Japanese immigrants, it was children and grandchildren of Japanese immigrants that were shipped off into, camps. There were about 8 of them in Arizona, by the way. So, the executive order, by the way, can executive orders be challenged as unconstitutional? Absolutely, right? So, Roosevelt's executive order was challenged. Did it violate the Equal Protection Clause? Was there a classification? Were whites being treated differently than Japanese? Well, of course. But the government had the Supreme Court said, in one of the most shameful decisions in the history of the Supreme Court, said, even though there was no evidence of sabotage, the Japanese went into court and said, look, you can't, U.S. government, you can't show one act of sabotage that's been committed by a Japanese person before this executive order was issued. And the Supreme Court said, well, it's wartime, there might be sabotage, we're going to give deference to the executive branch in wartime to their decision making. Think about, was Trump's executive order excluding people from those Muslim countries, was it upheld by the Supreme Court? Yes. The Supreme Court says we're going to give deference to the president during, on foreign policy, national security issues. Compare that to New York Times versus U.S., one of our 15 required cases where the Supreme Court says, yeah, we would normally give deference to the federal government in national security affairs, but no prior restraint overrules the supposed compelling state interest in keeping the Pentagon Papers secret. All right? Remember that? Good review. Go back and listen to that again. Make sure you followed me. All right, so in Korematsu, I'm going to touch this to make sure it doesn't turn off. All right? In Korematsu, the Supreme Court upheld the internment of Japanese. Brown versus Board of Education, which overruled what case? Which reversed Plessy v. Ferguson. Now, you have to know the difference between the Plessy reasoning and the Brown reasoning. The Plessy reasoning said is separate facilities don't violate the Equal Protection Clause if they are equal. Remember, state facilities. The railroad was a state-run railroad. This doesn't apply to private discrimination. We're going to talk about that with the Civil Rights Act. All right? So, if the state has separate facilities that are equal, all right? This does not include a water fountain at a restaurant. This does not include a restaurant. It includes something like a railroad that is run by or heavily regulated by the state. All right? Brown said separate schools, even if they are of equal quality, are inherently unequal. Why are they inherently unequal? Because, and put this in your notes, because it stigmatizes black people and makes them feel like they're being treated in an inferior way. Right? Okay. Loving versus Virginia. Can you believe? I mean, I was 6 years old when this law still existed. It was illegal in Virginia and a bunch of other states for a black person to marry a white person, or a Latino person to marry a black person, or any combination. Whites could only marry whites, Latinos could only marry Latinos, blacks could only marry blacks. Now, if you read the case, they made two arguments. They said, number one, this is post-Griswold, right? Marriage is a fundamental right, protected under the right to privacy, and because it's a fundamental right and being infringed, states have to show a compelling state interest, narrowly tailored to achieve the goal by least restrictive means, and the court said, no, there's no compelling state interest in keeping black and white people from marrying. They also argued equal protection. There were two classes of people, white people and mixed race, white couples and mixed race couples, and they were being treated differently. And the Supreme Court said there's no compelling state interest in preventing a black person from marrying a white person. The law violates the Equal Protection Clause. Obergefell, the gay marriage case, is so interesting. There were two analyses in that case. Marriage is a fundamental right, protected by the right to privacy, recognized in Griswold and Roe and those cases, and there's no compelling state interest in defining marriage between just a man and a woman. Remember, we had talked about those arguments previously. The state said, well, a marriage is for having babies, and then they said, well, then why do you let old people that can't have babies anymore get married? They said, well, raising kids in a mother and father home we have a compelling interest in that, because that's best for the kids. And then the gay marriage lawyers said, well, but you're putting tens of thousands of kids into foster homes in gay households, knowing that they're gay, and you are allowing gay people to adopt, not a couple, but allowing a single person to adopt, knowing that they're putting a child into a gay home, right? And the Supreme Court said there was a violation of the Due Process Clause and a violation of equal protection. What's interesting about the case, when you read it, the majority doesn't talk about what? It dodges the question about whether gays are a suspect class, a discrete and insular minority. Boy, they sure look like it to me, don't they to you? The Supreme Court just really didn't talk about applying a strict scrutiny standard. The majority just kind of dodged that, and the dissent screamed by saying, wait a minute, in no other cases have we had sexual orientation, have we treated it as a suspect class, Okay, now, in equal protection law, there are three standards. There is the strict scrutiny standard, the intermediate standard, which the Supreme Court applied to cases where men and women were being treated differently. I tell you what, my gut instinct is they're not going to go this deep on the AP exam. I don't think they're going to talk about gender cases. But there was a second lower level of analysis, not strict scrutiny where the law was presumed unconstitutional, but this medium one where there's no presumption, the government just has to show that the difference in how women and men are being treated was substantially related to a government interest. I'll be honest with you, I don't think you have to learn this middle ground. But there's some interesting cases. Under this standard, the Supreme Court struck down a state law that said women could buy 3-2 beer, something we don't have around here, but in the Midwest, they have a beer called 3-2 beer, where the maximum alcohol in the beer is 3.2%. Most regular beers have alcohol content at like 4.5% or 5%. So it was like a low-strength beer. and they had laws that said women could buy it at 18, but men had to wait till 21. Now it's interesting. The government came in and said, look, boys get drunk and they wreck their cars and they kill themselves and they're stupid and they get in fights, and women don't do that. So, you know what? Our law differentiating the treatment of women and men was substantially related to an important government interest. I tell you what, I think that's a good argument. Supreme Court said, no, we don't buy it. Interesting, this is a federal case. This is not a 14th Amendment Equal Protection Clause case because it's the federal government and not the state government. But, and I'm going to come, I'll come back here. This is a reference to this note. Isn't this baloney? Now, in the Fifth Amendment, when you read it, there is a due process clause that is enforceable against the federal government. There is no equal protection clause in the Bill of Rights. But the Supreme Court, in cases like the one we're talking about, said, well, the due process clause has an equal protection component. So the Supreme Court has gone ahead and applied equal protection clause analysis to the federal government, even though the 14th Amendment doesn't apply to the federal government. Go figure? All right, back to this case. Okay, so in Rostker, the Supreme Court upheld the federal law that said women don't have to sign up for selective service or the draft. By the way, men, you to this day, men have to sign up for selective service and women don't. All right, this you need to know. You need to know level 3. So all other laws that don't involve classifying people that are a suspect class, all of those laws that put people in different categories, the law is presumed constitutional. The law is upheld if it is supported by a rational basis. Rational basis. Do you guys get it? Under this standard, a law has to be irrational, which means just crazy and ridiculous for the Supreme Court to strike it down. All right, so go back to driver's license for 16-year-old. Is there a rational basis on that? Yes. Drinking age. Is there a rational basis to support that? In other words, was the legislature cuckoo, or did they have any plausible justification for passing a law that treats those two groups differently? All right? Look, you can't attack a law and win on the rational basis standard, because it's really easy to find some sort of rational justification for a law. The fascinating thing about the gay marriage case was, up until Obergefell, sexual orientation was not considered a suspect class. And if you read Obergefell, the majority, they don't definitively say we are now, as a Supreme Court, going to treat gays as a suspect class. That's why the dissent was howling about it. They're saying, you know what, under a rational basis test, the gay marriage laws that restricted marriage to a man and a woman pass the rational basis test. Gee, why was it a 5-4 vote? The liberals on one side and conservatives on the other. This is an interesting case to me. It was written by Justice Douglas, the most liberal justice on the Supreme Court. He was super old. He's like probably the last guy, one of the last guys. Maybe Brennan was there too, from remnants of the Warren Court. Why do undocumented immigrants get to go to school at Bradshaw Mountain High School? Why are they allowed? Well, because of the Supreme Court case of Plyler v. Doe, where the Supreme Court struck down a